Welcome back to Law and Crime, everybody. I'm Jesse Weber, and thanks for joining us. We're about to jump back live in the Eric Boyd trial out of Tennessee, our main live trial we've been focusing on for several days. All right, let's get some fresh perspective about this case. Joining me is trial attorney Byron Browne. Byron, great to have you here on Law and Crime. We haven't had a chance to talk about this case, so there's a lot to dissect here. How is the prosecution doing so far at establishing that Boyd is responsible for either the murder, the rape, the kidnapping, or the robbery of this young couple 12 years ago? He's already been convicted of being accessory after the fact, but did he do more? What do you think?
Yeah, I think it's really clear that the prosecution has a great case against him. I think the testimony of Thomas was very damning for Boyd's defense, and it helped out the prosecution tremendously. Admittedly, Thomas is a biased witness, and he used that testimony to curtail his time back significantly. But I think in the totality of circumstances, Boyd's defense just can't overcome everything that the prosecution is putting out there. And we just heard over 100 pieces of evidence. And again, possibly not all of those pieces, and more likely than not, are relevant. However, it just goes to show how much evidence is involved in this case. And the fact that, his co-conspirators have already been sentenced, and significantly sentenced, I think goes a long way for the prosecution.
Well, let's play devil's advocate here. So you could say he knew them, he knew the defendants, he helped the defendants. That's maybe true after the fact. But if his DNA is not found at the crime scene, and you have George Thomas, whose testimony is questionable considering the fact that he's a man who's convicted of being a part of this entire attack, and yet he gets on the stand and says he didn't hear anything, he didn't do anything, he thinks he was wrongfully accused. I mean, doesn't that hurt the state's case? I mean, what really do they have concrete to show that Boyd is responsible for the deaths of these two young people?
And you're right, there isn't a lot of direct evidence against him. There is the holster of the gun that was found in the car that Mathis lent to Boyd, and then Boyd's fingerprints were found on that holster. I think that evidence is significant, but the most of the evidence I think that the jury is going to rely upon in this case is circumstantial evidence. You have Jenkins, who was training for his commercial truck driving license, who saw that white Pontiac out there. We know that Boyd was driving that white Pontiac. He borrowed it from his cousin Mathis, and there's people coming in and out of that house all night. Again, Jenkins testified to that. I think there's enough circumstantial evidence. You don't have to see it rain outside to know that it rained when the ground is wet. And I think that's what the jury is going to rely upon in this case, is that circumstantial evidence. And there's enough of it that they can draw the conclusion that Boyd is guilty.
Yeah, and couple that with the fact that you talk about the white Pontiac. When Boyd's mother went into that car, she found this small plastic bag containing bullets underneath the front passenger seat. Again, another piece of damning evidence against Boyd. But there's room for the defense to move here, right? There's room to create reasonable doubt. If you were his defense attorney, where would you go with the case once it was handed off to you? I mean, what kind of witnesses would you call?
Well, that's the thing. I mean, no witnesses have come forward. I don't know how Boyd has any defense to this case, and I've thought about it hard. But if Boyd had a witness or someone that could substantiate the fact that he was away from the crime scene at the time, which he alleges, or at least is being argued, I should say, then you would think that witness would come forward. The fact that we haven't heard any direct evidence to support the conclusion that Boyd isn't involved, I think in and of itself proves more likely than not, or sorry, I should say beyond a reasonable doubt, that he was involved. So I don't know what the defense really has to stand on.
Well, we're going to wait and see. We're still in the early stages of this case, day 4. Let's take a break. Byron Browne and I are going to be back to break down everything that you're seeing in this courtroom. Stay tuned. Okay, the collection of evidence and what DNA and whose DNA is on what, always important in every case. But Byron, are you hearing anything about Eric Boyd's DNA being where it needs to be for the prosecution to make its case?
Great question. And if you're the defense, you love what's going on right now with that DNA analysis with Millsap's testimony. You hear a lot of Cobbins, you hear a lot of Davidson, you don't hear anything about Boyd. And when you hear these stats echoing throughout that the sample cannot be replicated within, or it exceeds the world's population, That's the stuff that Boyd's defense is really going to hone in on. And right now, in my opinion, that's the strength of the defense, is that, hey, look, we got all of this DNA evidence, and we captured it from a lot of different places, and none of it places Boyd at the scene. I think that's a huge strength for his defense.
Yeah, and look, what happened earlier today was the defense didn't even want this witness talking about the sperm stains found on Eric Boyd's clothing because they're not the victims. The victim's DNA is not on his clothing whatsoever, and they didn't want the jury to be confused by hearing, well, you know, you have Eric Boyd's clothing, there's sperm, what is that about? Really, it has no relation, but at the same point, the judge says it is important for the jury to hear this. We'll break it down. Let's take a break. When we come back, we'll be live. Byron, I got to tell you, this is a great case against Lamarcus Davidson and against the co-conspirators and the co-defendants. I'm not hearing a lot against Boyd, and in fact, we were just talking, I'm not hearing a lot against Mr. Thomas as well.
Yeah, and it does surprise me about Thomas. You got to think, if you're the defense for Boyd, you want to bring up Thomas's name as being involved within this crime, and if there's any DNA or any hard evidence to link Thomas to the crime, you want to bring that out. And why you want to bring it out is you want to attack the credibility of Thomas. But to your point, all you hear a lot about Davidson, a lot about Cobbins, and nothing about anybody else. And so you're right, it's a great case against Davidson and Cobbins. And the other thing I think that Boyd has going for him now on his defense is that they're able to argue to the jury, look at how much evidence, DNA evidence, blood from bedrooms, from rugs, from sheets, from shirts, has been brought forward. And if Boyd was involved in this in the least, for sure we would see some DNA evidence or something linking him to the crime. So I got to go back on what I said earlier where, you know, his defense was really weak. I believe this testimony from the DNA analysis is helping his defense exponentially at this point.
Yeah, it's pretty incredible to hear what's actually happening. But again, you know, they do have to tell the larger picture of the story. They can't tailor it and sugarcoat it each way. They have to tell. They can't just talk about the story of Boyd without talking about the story of everybody else.
Correct. They got to bring everybody else into it. And again, if you're the defense, this is exactly what you want to do. I call it cooking spaghetti. You want to throw everything against the wall and hopefully something sticks, because all the defense is trying to do is create reasonable doubt. And if they can, then Boyd is going to get off of these particular charges.
You know, this is going to be a bit interesting day, not just with the DNA, but we also believe the medical examiner is on standby to testify today, maybe the last witness called by the state. This is something that we've seen them do before in previous trials, really tighten up that case and let the last thing the jury will hear from the state in the presentation of their evidence is the medical examiner. It's an important strategic move. We'll talk about it. Let's take a break on our end. When we come back, we're going to be live. Stay tuned.